Good afternoon, everyone, and welcome back to this week's episode of Digital Law News. So just for those who don't know, Digital Law is a niche law firm based in the UK, and we specialise in things to do with data protection, digital law and technology matters as well. So I'll just pass over to Peter just to introduce himself, and then we'll get started.
Thank you, Laura. My name's Peter Wright. I'm a solicitor and the Managing Director at Digital Law. And we are currently very busy advising our clients all around the world with regards to everything from e-commerce to telecommunications to data protection, cybersecurity issues. And we've got some interesting stories to share with you this week. As you can imagine, we always stay up to date in terms of what's happening around the world in relation to different pieces of everything from data protection enforcement to stories of people being hacked. And we've got some really good stories to share with you. So I'll pass back to Laura to start taking us through them.
Thank you. So the first story today is in regards to law firms and Google rankings. So this story is from the Legal Futures, and they've come out with a report basically saying that the Google algorithm is due to be updated, and because of this, a lot of law firms are set to suffer a major ranking penalty from Google. And this is based on their failure to update the search results algorithm. So this is all to do with websites being compliant, and a legal digital marketing specialist found that almost two-thirds of the top 200 law firms actually scored less than 50 out of 100 in overall compliance test. And very few of the major city law firms actually performed well in this, just scoring just a shade over 50. So it's the first time that Google have actually announced that they're going to be doing this update of their algorithm. Usually they just do it without even saying anything, so people don't have any time to kind of counteract the effects. So I think this is just basically a reminder to make sure that all websites for law firms and other companies are up to date and compliant, so that they are still staying up there in the ranking.
Indeed, thanks, Laura. I think it's a fascinating story because we know that Google does quite frequently change that algorithm. They have got in trouble in the past, sometimes for the way that their algorithm works. Don't forget, a few years ago, Google was fined by the European Union based on the fact that it was manipulating its search results and placing, say, products that were for sale higher in its search rankings if it was being sold through certain Google platforms rather than other vendors who had high search rankings there before. And some of those vendors had a catastrophic drop down the rankings as a result. They had previously sort of been on the first page and then suddenly found themselves dozens of pages back in those search rankings. And as we know, people rarely ever go on to the second page of a set of Google search results. So if you're not on the first page, you very often have to forget about it. And interesting here that a lot of these firms that have spent a huge amount, and given that Digital Law, we have a website, and indeed it's one of the most horrifically expensive things that we've ever put in place. But nonetheless, those top 200 firms will all have spent an awful lot of money on their websites and their branding, and they'll be quite disappointed to see that many of them stand to lose out through this change to the algorithm. So there is a piece of research that has been done that is quoted by Legal Futures there by Legmark. If you go to legmark.com/legal digital 200, they have published the details whereby they've gone through those top 200 firms and they've listed the ones that they think will be performing poorly as a result. But I think it's an excellent illustration of the fact that this algorithm is changing, and it's actually a big wake-up call to those who are out there. If you are heavily reliant on where your website comes out on Google's search algorithm, be careful, because you wouldn't want to drop down those rankings again. It will be interesting to see if any particular platforms are penalized by this. It may end up resulting in that same sort of enforcement against Google as we saw a few years ago. But what's a fine of a few million euros for an organization like Google that turns over billions of dollars every year? Not a huge amount. So that they will continue to do what is best for their business rather than necessarily taking a huge amount of regard for what the European Commission may turn around and do.
Yeah, absolutely. And I think you mentioned, Peter, that there is like a link on there to show you what you can be doing to make sure your website is compliant. Is that right?
That's absolutely right, yes. So the story's on legalfutures.co.uk, and then if you click through that to the Legmark site, it gives a full rundown of how and why these 200 firms might be struggling, and then it gives you an opportunity to list, to actually sort of put in your own domain name and see how that is doing. It's a tool designed for law firms, but as I say, multiple sectors are going to be affected by this, not just law firms. It just happens to be Legal Futures, which is directed at the legal market, that has picked up this story. So ironically, if you go and Google this story, I'm sure lots of information will come up.
Yeah, absolutely. Thank you. So moving on to our next story today then. This is a follow-up story from last week in relation to FatFace. So for some of our regular listeners, you may have remembered that last week we spoke about a cyber attack on FatFace and their basically a delay in reporting this, especially in terms of making their employees aware that their data was at risk. So this is a story in relation to a ransomware attack that has now come out. So the attack actually took place in January of this year. I thought that they paid $2 million to the ransom firm Conti. So that's a ransomware gang. And basically the gang told FatFace that it originally breached their network via a phishing attack on the 10th of January in 2021. They then used this to gain access to admin rights and to expand its reach throughout the network, as well as identifying the firm's Veeam backup servers and Nimble storage. They then carried out the final attack on 17th of January 2021, when the criminals were then able to exfiltrate over 200 gigabytes of data from FatFace systems. The ransom was supposed to be $8 million, and they agreed to a lower amount after they basically agreed that they didn't want to bankrupt FatFace, which is very nice of them. But they have then since offered advice to the company's IT team on how to strengthen the security of their systems and prevent cyber attacks in the future. So I think this is just another ransomware attack that will probably keep on happening, no matter how much more aware people are of them.
Indeed, thank you, Laura. So it's a really interesting story, this, on computing.co.uk, which gives this extra colour, this extra detail that we didn't have when we covered this story last week. The size of the ransom at $2 million is large, let alone the $8 million they're originally going to charge. I mean, like you say, Laura, it's very big of them to have reduced that. I love the way it says, oh, when they provided guidance to FatFace on how to make sure your system is more secure in future so it doesn't happen again. I wonder how they did that. Did they send an email saying, click on this link? just to get the point across. But I think this is also a good example of what an ongoing cyber attack looks like. Anyone who is familiar with the cybersecurity kill chain, the sort of 8-stage breakdown of what an attack looks like, this is illustrating it very, very clearly. So at the top, I mean, they'll have originally scoped out FatFace, they'll have found how do we take them down easily, and they'll have worked out how they were going to send this phishing communication to them. So they'll have spotted which email addresses, and probably which email addresses had a propensity to be opened and would both open the email and then click on it. They will have targeted them, so the email will have appeared genuine to whoever used it. They'll have got around the spam filters. It was probably specifically a piece of spear phishing targeted at specific individuals, specific recipients, and designed to make them open it, rather than something generic that would have been easily ignored. And then once having got into the system, they've sent the phishing email, they've got in, and they've then taken 7 days to get full command and control of the system. So that, gaining admin rights. So after you've got those admin rights, they would have been able to open new accounts. They would have been able to potentially lock other people out of there. But it looks like they spent a week working out exactly what they were going to do, and they identified the data they wanted to get, that 200 gigabyte of data, and then they exfiltrated the whole lot on the 17th of January, locked the system, encrypted the machines, and said, pay up or the whole lot goes. So it just shows really what these things look like. They are not quick and instantaneous. They are very often the result of ongoing surveillance and an ongoing attack. And this just shows the way that a whole organization can be paralyzed. I mean, okay, they turned around and reduced it to 2 million, but either way, it's millions of dollars, and who can frankly afford that? Particularly if you're in retail at the moment, they've got loads of stores, hundreds of stores that are closed, and staff that they probably can't afford to pay and have had to furlough, and then this comes along. I mean, $8 million might have pushed them over the edge. I think 2 million might. No one knows at the moment. You can presume that everything will open up and you can start selling huge amounts, and you can hope you'll rely on your e-commerce. But I'm sure they haven't catered for losing $2 million to hackers. So I'd say they probably still aren't out of the woods yet.
Yeah, absolutely. And I think that's a very good example of like the cyber kill chain. I know I've spoke about that in some training that I've completed before with one of my colleagues. And it is like, I think a lot of companies forget about how they do the whole surveillance in the background, and then it takes them a while to then get inside and figure out the whole process. I think a lot of companies think that things like that, just they get in and they take the data and it's all done within a couple of minutes. But it is a full process, and yeah.
Exactly. It doesn't happen in the blink of an eye. And they would have been very specifically targeted for this and taken down. And unfortunately, they, clearly a large organization, thousands of staff, hundreds of shops, their system, whatever they were doing, was not enough to prevent this catastrophic breach.
Yeah, absolutely. So staying on the phishing front then, our next story is in relation to the Royal Mail message that has been going around. And I know this was mentioned in last week's episode as well. So this is the text that is being sent asking people to pay, I think it's like an additional $2.99 in order to receive their package. And I think they try and link it to Brexit and things like that. So the texts have been sent to millions of phones across the UK in recent weeks. And within the past year, fraud victims themselves have lost a record of £479 million. And this has led to the National Crime Agency saying that scammers are finding it way easier to bombard the public with millions of fake texts, emails and phone calls. An investigation carried out by Moneymail actually revealed that cybercriminals are now evading detection by using cheap Chinese technology to beat the flimsy barriers put up by banks, telecom firms and regulators as well. So I think it's just showing that how they're getting around this and why this is becoming more common.
Indeed. So fascinating story, this from thisismoney.co.uk, and it includes screenshots of this Royal Mail fake text message that is being sent out to people saying, you've got a delivery, we've held on to it, and you have to pay an extra amount for it to be released. Very often the pretext, as you quite rightly said, is Brexit, saying, there's unpaid duty on this, for example. Yeah. But surprise, surprise, it isn't genuine. I mean, when you look at it, the domain on there, it doesn't say Royal Mail. It does have the words post office in there along with several other words, but it isn't a genuine domain. And I think this thing has been incredibly popular when it's been sent out. I mean, it's getting to the point, I think, that for most of our listeners, I think I may as well ask who hasn't received this text message, to be perfectly honest. There we go. The domain that it's trying to use is called postoffice-myfees.com. So surprise, surprise, that's not a genuine domain, but it's trying to get people to then click on the link and then go through, and of course you'll end up paying an awful lot more than £2.99, and then they start then sending other things to you. And there's a case study in the article. Actually, I think it's the actress that we talked about last week who ended up paying £1,000 that she thought was in relation to this, and it was all through the same scam where the hackers then After she paid that $2.99, they impersonated her bank. They told her her money was at risk, and surprise, surprise, you need to move your money to a safe account. There is no such thing as a safe account. Your bank will never call you and do this, but there is certainly an epidemic of people impersonating banks, calling up and trying to bounce people into making these sorts of transactions. And unfortunately, they continue to be successful. So this is, I think, a salutary warning just to be incredibly careful of what you receive. And if you do receive a communication with regarding an undelivered piece of mail, it's usually going to be via the post, because, of course, they've got mail addressed to you, which has your home address on it. So they will have to write to you because they don't have your phone number is the giveaway. So you know, just continue to be vigilant with all of this stuff, I think, is the message.
Yeah, I think the key message here is just to be aware of it. I know most people are probably aware of this now, but people still keep falling for it. So I think it's just being vigilant and double checking things before you actually click on the link.
Exactly. And I should say as well, and a quick message to always say to people as well, beware of COVID phishing as well. So people using text and emails related to the pandemic, always check, is it actually from the NHS? Is it actually from your genuine surgery or not, the communication that you are receiving? And never reply to it. Use the genuine details that you have elsewhere stored to then speak to your GP or go to the NHS website itself, nhs.gov.uk. But don't trust any links that are ever sent to you via SMS or email in that regard.
Yeah, absolutely. Thank you. So the next story for today then is in relation to the Dutch Data Protection Authority and their fine for Booking.com. So Booking.com have been fined €475,000 in relation to a data breach where criminals accessed the personal data of more than 4,000 customers, including obtaining the credit card details of nearly 300 users. So the criminals extracted login details of the accounts of from employees of 40 hotels in the United Arab Emirates, and this is how they gained access. So Booking.com actually was notified of the breach on the 13th of January. As we know, there is under the GDPR and obviously the Data Protection Act that applies in the UK. So the GDPR in particular here, there is a mandatory 72-hour notification period from when you are aware of that breach. And they didn't comply with this, basically. They waited an extra 22 days to report the breach. And I think this is what has actually triggered the fine. So the Data Protection Authority have said that this is a very serious breach. A data breach can happen anywhere, even if you have taken good precautions. But to prevent damage to your customers and repetition of such data breach, you must report this in time. Speed is very important. So I think this is just a reminder. We always say about the reporting of data protection breaches, making sure that it is done within 72 hours. And this is just a reminder of what can happen if that is not done.
Indeed, thank you, Laura. You covered the main points there with regards to the 72 hours, and I think that's why the data protection regulators decided to make an example of Booking.com here. But I think it probably couldn't have come at a worse time for Booking.com. Don't forget, the travel industry at the moment has been absolutely knocked for six by the pandemic and is currently flat on its back and sort of in need of resuscitation. And it's pretty cataclysmic really for Booking.com to then have this happen to them. Even though it's only a small number of their customers, you know, credit card information of 300 users, 4,000 customers affected in total. It's just the blow to your credibility. I was talking to a in-house security officer recently who was telling me that the measures they took to keep their organization safe were way above what is needed from a legal and regulatory compliance perspective. So they weren't worried about complying, just making sure they complied with GDPR. So we cannot afford a breach. If we have a breach, we will lose our big corporate blue chip clients. So it cannot happen. And I think that is increasingly becoming the case for a lot of organizations, and arguably, you know, if you're Booking.com, that's similarly for you. You can't afford for these sorts of breaches to happen. because it just puts people off, particularly when, after this year, people then want to book and hopefully travel safely and securely. You don't want to suddenly find that you might be at risk. And the trouble is, we have to now rely as well on online travel agents. I don't know about where our listeners are around the UK and around the world, but there are not many physical travel agents left. There's an awful lot of them that had just about managed to survive up until the pandemic, and a lot of them have now closed and moved on. So you have to book your travel online, unfortunately. But a reminder to think very, very carefully about how and where you do that. And if you are using an agent like Booking.com, I'd do a quick search online beforehand just to see what their reputation is like. Have they been the victim of any cyber attacks, or indeed have they paid up when there have been problems with some of the bookings that have made? Are they a member of, for example, the Association of British Travel Agents, so at least your travel is covered if something goes wrong? All of those conditions are still very important to think about before you rush to book that first trip away after the end of the lockdown conditions, which I think we're all pretty brassed off with at this point and looking forward to the end of it. So don't stampede to book those flights without checking first. Yeah,
absolutely. I think you've covered everything there. So moving on to our final story for today then. So this is in relation to Supermax and their CCTV policy. So Supermax, I believe, is a Irish corporation. I think it's a fast food company, and basically they're having a collision course with the Data Protection Commission in Ireland over their policy of not supplying CCTV footage to people who are seeking compensation for injuries they say that happened on its premises. So the Commission is handling complaints from their customers who have been refused footage despite requests made under the General Data Protection Act. So the owner of Supermax has previously said that his business would no longer comply with requests for videos in cases where people were suing them. Last year as well, they actually won a High Court judgment, and this wasn't in relation to GDPR or subject access requests directly. However, the judgment did say and basically concluded that they did not have to release the CCTV footage to the plaintiff of the case. So they're kind of using this judgment now to argue that they don't have to do this for other subject access requests under GDPR. So I think this just comes back to the point that so often provides for a lot of confusion in terms of when a subject access request is made, what information does actually need to be provided in terms of, is it just the information that's stored? For example, yes, we do have you on the CCTV, or is it the actual physical data itself? And I think it just shows that a lot of people are abusing the purpose of the subject access requests and kind of using for them purposes as like a phishing exercise rather than their actual purpose as well.
Indeed, thank you, Laura. I think this is a fascinating case because it is highlighting the abuse really of the subject access request, where very often people are using it to coerce an organisation to supply information that could then be useful in future legal proceedings against the provider of the information or anyone else. And in this scenario, just because you're making the subject access request does not mean you are automatically then entitled to receive the CCTV recording, and that's what Supermax really is trying to ram home here in terms of its position. So it looks like it may end up having an argument with the Irish Data Protection Commissioner over that, but at least it will actually be a really good test case to basically say, what do you physically have to provide pursuant to a subject access request? And we've ended up, as you know, Laura, with our clients, we have a lot of clients come to us and say, look, we've had a subject access request. Do we have to carry out this massive search and then disclose potentially thousands of emails, or we've got these documents? Do we have to supply hundreds of documents because a individual is named in there? And very often we advise them, no, you do not have to do that. It's more about a request in terms of details about how that personal data is stored, not the supply of the records themselves. It isn't a Freedom of Information Act request, it's a subject access request. And this is a high profile one. I mean, I must admit, when I was reading this, I'm afraid I hadn't heard of Supermax before. I understand that in Ireland, they're a massive fast food chain. How they've got away with calling themselves that when there, of course, there is another global fast food chain with Mac in the title, but they appear to have done it in Ireland, and they appear to have the muscle here to say, look, we've got a lot of venues across the country, and we have a lot of CCTV, and we don't think we should have to then review hours of all that footage and slice it and dice it and send it out to people just because they've asked to see. So in other words, you're saying, you've made your subject access request. We confirm that we have CCTV in the following locations, and it would have recorded you, and we record that information securely, and it's on our servers here, and it's encrypted and it's secure. But so you're giving them the information about the personal data, but you're not actually giving them a copy of that personal data, even if it just comes down to being a screenshot of the recording, because that, again, might be pretty onerous for someone to have to wade through and then find out exactly where that person is recorded or how many times that might happen. So it will be interesting to see what the Irish Data Protection Commissioner comes out and says on this, bearing in mind that it's the Irish regulator that in turn is responsible for regulating Facebook, Apple, Amazon, Google, all of those tech firms, because they have their servers based in Ireland for all of their EU data subjects. So what the Irish Data Protection Commissioner says will have a significant impact, and I can imagine, I would be surprised if this is something that isn't being discussed in meetings of the European Data Protection Board as a result, and you would expect that whatever the Irish Commissioner says would then subsequently be implemented across Europe through the mechanism of the European Data Protection Board.
Yeah, absolutely. So that's everything that we've got time for today in terms of stories. We just wanted to give a little reminder about the GDPR compliance manual for legal practices. So this is on offer at £99, down around 50%. So it is targeted towards legal practices, but we have found that a lot of people who bought this from other regulated sectors such as financial services and things like that have found it useful. So I'll just pass over to you, Peter, just to give a little bit more information about the manual.
Thank you, Laura. Yes, so this is our practical compliance guide for GDPR, which actually has in it the helpful forms, templates and checklists to allow you to get a start and to establish your compliance with GDPR. GDPR is great at telling you, you have to reach this standard, you have to report this in 72 hours, you have to show that you are keeping records of consent, but it doesn't tell you how to do all of this stuff. Yeah. This manual does forms, templates, checklists, and it sets out in clear, plain English exactly what you need to do and how to do it. And indeed, it's been, while it is designed for law firms, it's actually been very popular with accountants, financial services, banks, even educational institutions who are wanting to get a grip on their data protection have found it to be quite helpful. So if you are interested in that, please do drop us a line and say that you heard about it through either this video that you're watching or through the podcast.
Yeah, great, thank you. And we just want to say a big thank you as well to Anson Evaluate, who help us produce these webinars every week. So just for those who don't know, Anson Evaluate is a training and consultancy company. So they provide online and in-person training, obviously when it is possible, to a lot of companies based around data protection and cybersecurity and other like technology matters as well. And they do help online businesses to be able to run their own webinars, provide training to their employees or to the general public if that's something they're after. So if anyone is interested in getting the help from Anson Evaluate or any of the services, just drop them an email at admin@ansonevaluate.com or send us a message through Digital Law, and then we'll be able to pass it on to them.
Indeed, and I think the main thing to emphasise here is that this is a production of Anson Evaluate, this podcast and this webinar. And if you are looking yourself to get online, to get a podcast, or to do some online training, online education for your staff or for your organisation, Anson Evaluate are experts at delivering bespoke training around anything from cybersecurity, data protection, or other compliance issues. And of course, as you can imagine, they've done a lot of that online over the course of the last year for clients who are based in multiple different jurisdictions all around the world, who've needed to make sure that their staff are aware of standards, aware of practices, even when they've been working at home or working in the difficult conditions of the global pandemic. So we can highly recommend Anson Evaluate for those sort of online training, online information needs, and to help you communicate effectively using everything from webinars, video to podcasts as well.
Great, thank you. So yeah, that's everything we've got time for today. So just a reminder that these podcasts and webinars are available through our YouTube channel, our website, and also as a podcast as well on all platforms such as like Spotify and Apple. So yeah, thank you once again for listening, and we hope to see you all again next week.